Attorney Cook. Would you like me to call you first?
This is Attorney Kendall. I would like to go first if possible.
No, I was talking to Attorney Cook, your sir.
Okay.
Thank you. You're on mute, Attorney Cook. You're still on mute.
Okay, yeah, I'd like to go first.
No, to talk to your client.
Yes, that's what I mean. Yeah.
Okay. 8122.
Okay. Okay, I'll get to you in just a minute.
Afternoon, Miss Bridgewater.
Good afternoon, Your Honor. How are you?
I'm doing well. Yourself?
Good, good.
When is the SAP reset date?
The 24th of September.
Thank you.
You're welcome.
Good afternoon, Your Honor. How are you?
I'm doing well. Yourself?
Doing great, Your Honor. I'll put on the chat my client. I'm here for Ms. Chavarria, Giselle Chavarria.
Okay, thank you. We'll let them know. I just saw you in traffic court, didn't I?
Yes, sir. I was there this morning. That's what I was afraid I wasn't going to make it here, but if I had known, I could have stayed there.
Good to see you.
See you.
Officer Melton, good afternoon.
Good afternoon, Your Honor. I do not know the position number for Ms. Chavaria. She's right here in front of you.
Okay, that's position number 5. Is it Giselle?
Yes, Your Honor.
Okay, that's position number 5. And let's see. It's right at 2 o'clock. Good afternoon, Mr. Vardy, I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video today. You have been charged in case 24 CR 006346H with battery family violence. Is there a history? Ms. Washington, good afternoon.
Afternoon. This is the defendant's first arrest. The defendant does meet the criteria for UJR jail. Nothing further.
Good afternoon, Ms. McConkey.
Good afternoon, Your Honor. How are you?
I'm doing well, thank you. Hope you are as well.
I am, thank you. This is a dual arrest with position 2, Edwin Astudillo Flores. But in regards to Miss Chavarria, this incident occurred at the incident location 3263 Wheeler Street in Atlanta. The parties are married but do not currently live together, and they do share one child. Defendant Chavarria arrived at the incident location and confronted defendant Flores about his relationship with another woman. During the verbal altercation, defendant Chavarria slapped him in the face while they were outside the home. The parties then went inside and defendant Chavarria again slapped defendant Flores in the face. After the second slap, it seems like defendant Flores got on top of her, then placed both his hands around her neck, causing her to be unable to breathe. Defendant Chavarria did have visible lacerations and marks on her neck, and defendant Flores did have bleeding lacerations to his face. Given that this is the defendant's first arrest, the state's recommendation is going to be a signature bond through pretrial services. No further contact with defendant Flores. Stay away from the incident location, as it's my understanding this is Mr. Flores's home. Third-party transfer of the minor child, anger awareness, and no drugs, weapons, or alcohol while out on bond.
Thank you. Yes, counsel.
Yes, Your Honor. I actually am surprised that the state was aware of the actual factual basis. I'm glad that it's on the report. As you heard, position number 2 in the calendar, it is the alleged victim. We would say also the other aggressor who strangled my client. I'm very surprised that he's only charged with battery when he should be charged with aggravated assault. If you can see, my client has some very severe markings after 3 days of being in jail from that. But today we were not at trial, so I'll just focus on the YALA factors. We ask that you grant her a UJR, Your Honor. She has no criminal history. She is a lifelong resident of Georgia. She has lived in Atlanta area, right now in Hateville, her entire life. She has lived at the address she's currently in is with her parents. They've lived there for 8 years. She moved in since June after they separated from husband. She is a Tri-City graduate from 2018. Did her dental assistant certificate in 2019. Again, no history at all. There's no need for her to have contact with the alleged victim. She does not want him anywhere near her. So we are willing to, we have no issue with a no contact order. As part of these type of cases, I always get my clients to do domestic violence classes anyway, whether or not they're guilty or they're the victims, because I think it helps everybody. But we would ask that there be no specific restrictions on her for reporting, because we also don't want her having to report to pretrial, Your Honor. I don't know if that's required or not.
I believe it is required to go through pretrial. So if nothing further, it will be a $2,000 signature bond through pretrial level 1. No further contact with Mr. Flores. Stay away from the Wheeler Street address. Third-party transfer of any minor children for visitation, and no drugs, alcohol, or weapons while out on bond. Okay. Good luck to you, ma'am. Anything further, counsel?
Nothing from the state.
No, Your
Your
Honor,
Honor.
that concludes my business with the court. May I be excused?
Yes, have a good afternoon.
Thank you, Your Honor.
Good luck to you, Mr. Chavarria.
Next, we have for Attorney Kendall, Miss Ashley Bell, Your Honor.
Okay.
Sorry, I don't have the position numbers at hand.
And this is Bell, B-E-L-L.
Yes.
That's correct, yeah, BELL.
Okay. I don't see this on my calendars. Ms. McConkey, do you know what position this is?
I don't see Ms. Bell on my calendar either.
don't
I'm not sure
either.
if there is an issue with the accusation, but I refiled it a couple minutes ago and I noticed she wasn't on the calendar.
Okay,
Your Honor, she was on the poll sheet this morning, but not listed on the calendar.
okay, Ms. Bridgewater, do we know why she's not on the calendar?
I have no idea, Your Honor, if she's on the pool sheet. I'll check on that. Just, can we go to the
Okay.
next one?
Yes, and so an accusation was filed, Ms. McConkey?
Yes, I filed one earlier this morning, but I just refiled it again in case for some reason it got lost in the
Do you
translation.
have the accusation number there before you?
Let me take a look and see if it has. No, I don't see that it's been given an accusation number yet.
Okay. So Ms. Bell, I'm gonna have to come back to you. I don't have an accusation number at present. So Officer Milton, if you're still there, do you want to go to someone else while we see if we can track that down? I'm not sure where Officer Milton went. Courtroom 2, good afternoon.
Hey, Judge Morrow, good afternoon. I
Good
also
afternoon.
have an issue, I have an issue with the calendar with the defendant. It's booking number 2415487, Miss Hugh Shea. She's not on the calendar.
Okay, does anyone know about Ms. Shea?
I don't know about the calendar, but I've interviewed her.
Hi, so your judge, your honor. So, this is Mr. Lee. I received a call regarding Miss Shea. So I'm the victim of the incidents.
Your Honor, that's my
Sorry.
case. We're prepared to address bond, but there's been no accusation filed and we're gonna just hold off on that right now.
Okay, and so she will not be showing up, right, today?
I don't know where we are on this. So what are we gonna do with her today?
Your Honor, you can address bond today.
Okay, well, I don't have anything as far as a
She's not on the
number.
calendar. I didn't file an accusation.
Right.
She's on our pull sheet. I spoke to the clerk about it. I said we could absolutely address bond, but I have not made a charging decision.
Okay. So Norris, does that answer your question, I guess?
I guess I could bring her up, Your Honor. You want to do her first?
Yes, that'll be fine.
Okay.
You're gonna have to tell me what she's charged with and because
Your Honor, I need to make sure that I have the criminal history available. Could you provide the booking number again for me?
My understanding is she's got no prior arrests. I'll absolutely give you the information that I have.
Okay, that's fine.
So has she not been accused?
No, she has not been accused. The booking number is 241-5487.
and let me know, tell me her name again, please.
Her last name is pronounced Shia,
And it's spelled how?
Xie.
And what's Ms. Shea charged with?
It was simple assault, family violence when arrested by the police officers.
That's correct, Your Honor.
Okay. Tell me what this is about, Miss Allen.
Your Honor, the police were called to the residence where the gentleman who just spoke up, Mr. Lee, and his wife live. He reports that they're estranged and that he was bit on the back. This is a Johns Creek case. I've reached out to the officer and requested body cam as well as more information. Both parties were on scene. They both reported an altercation. They both reported being assaulted by the other. There were minimal injuries. Mr. Lee reported he'd been bit on the back. That's not what police saw on his back. The defendant in front of you is 21 weeks pregnant. They share a child. And it looks like they were arguing because both of them were recording each other with a cell phone while they were arguing. I think divorce is something that is on the cards here. We'd be in agreement for a SOB through the jail, Your Honor, with no violent contact. And at this point, we have not made a charging decision, and that's going to be pending when I get more information.
Okay, tell me again, what's she charged with?
Simple battery.
Well,
Simple battery, family violence.
Right, the original was simple assault, but that will be upped.
No, if that's what it is, I'm not doing anything. It's simple assault if that's what the warrant is.
That's what's on the 3 card.
Okay, thank you.
And that's what's on the affidavit for arrest.
Okay, thank you. Mr. Lee, if you would like to address the court, now is your opportunity to do so. I'll need for you to unmute yourself, activate your camera, and I'll have to swear you in. So if you'd like to address me, raise your right hand for me.
Yes,
Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
yes.
Okay, yes, sir. What would you like to tell the court?
So what happened on Saturday night was that we were in an argument. So I started videotaping, and that was a suggestion from an officer who responded to a previous case. So I started videotaping, and Miss Shea got close to me, and she lost the control. She was trying to take away my phone and stop me from videotaping. The videos were cut off at that moment. So I shared the videos with the officer who requested it. So she grabbed me on my arms, both my arms, trying to take away the phone from me. I wouldn't let it go. And then, so she was wrestling a little bit. I was trying to get away. And then I bent over. She biting me. So she has beaten me on my back. So she used her teeth to bite me. And also there was a minor scratch which I found out later. I was wearing a bracelet. The bracelet was broken maybe because of force, or maybe because her nail. So, and then I had to run away. We were on the 2nd floor. So I had to, because I wanted to avoid any physical contact. So I had to run to the 1st floor to call 911. And so when during the time I was on the 911 call, I was waiting for the officers, and she started to call the police officer. So I'm not sure where she talked to the officer, but I never did anything to her. All I did was to try to get away and avoid physical contact with her. And
Do you two live together, sir?
yes, we do.
Okay, and where do you reside?
In Duluth,
What's your address?
7220 Amberley Way, Duluth.
And I take it that you don't want to have any contact at the present time?
So I was asked this question, and I was thinking, even though she
One moment,
is
Mr.
not,
Lee. Your Honor, our office has been in contact with Mr. Lee, and he said he wanted to wait to see what the defendant said in court today to decide whether or not he wanted to have contact. When the defendant in front of you spoke to police, she reported that they argued and had a physical altercation because they were both videotaping each other. Both the defendant and the victim showed police videotape that they'd taken on their phones. He reports that she bit him on the back. She reports that he was violent to her and used his back to press her into a wall, and she's 21 weeks pregnant. She went from the scene to the emergency room, Your Honor. I asked for any prior police reports from Johns Creek, and there are none. I have requested any calls or reports related to 911 calls or calls for service just to do my due diligence here, Your Honor. But these two share a child, and they're in the process of divorce. The argument looks like it was about access to that child. And so these are people who clearly don't need to be living in the same home. So we'd ask for no contact and a one-time escort. But ultimately, I'm not sure who the primary aggressor is or how that was determined, Your Honor. A woman who's 21 weeks pregnant who goes to the hospital as a result of this, and they're both on scene with stories that are alarming. I'm not sure how the decision was made, and I'm not going to file an accusation today until I know more.
I'm just trying to find out who I need to not be in the house. So do you have somewhere else you can go, Mr. Lee?
Not currently.
All right, let me talk to afternoon, Mr. McLean.
Good afternoon. I asked my client if she had any place to go. She could think of nothing, so I told her about shelters.
Well, I'm not gonna have, I mean, she's pregnant. I'm not gonna have her go to a shelter.
Exactly. They have no friends, phone numbers, no family in this country.
That's part of the concern that the state has, Your Honor. These are particularly vulnerable individuals, and if they share a child, I don't have any indication police spoke to that child. There needs to be some more work done here.
Well, I don't have time to do the work because I've got to decide where, and I don't have any jurisdiction over Mr. Lee, so I can't not make him go somewhere.
I didn't ask you to do anything other than to just give her a bond, no violent contact.
I'm not getting on in this, Alan. I've got to do my job, and my job, one of those things is trying to keep these two apart and trying to make the best decision. I'm not going to put her in a shelter while she's pregnant. I'm just trying to figure out what I need to do. I don't have an accusation before me. You know, it's just a bit frustrating to start this way this afternoon.
The existing is 5, Your Honor.
So I'm going to give her a signature bond through the jail, a $2,000 signature bond through the jail. No further contact with Mr. Lee. No contact means absolutely no contact. No phone contact, no email contact, no social media contact, obviously no personal contact. Given that there's no contact, I don't have any jurisdiction over Mr. Lee. He's not charged with anything. So she's got to find someplace else to reside in the meantime, Mr. McLean.
Right.
No drugs, alcohol, or weapons while out on bond.
Your Honor, may I say something?
Yes, sir.
So she doesn't have income. She uses my so she's like a guest holder of a credit card that I owns. So I don't know where she can go. So that's why first I wanted to see if she realized that she made serious mistakes, and that's why I have been considering the nonviolent contact, because
That's out
vulnerable.
that's out of your hands right now, Mr. Lee. So I'm not going to have you all be around each other, given the allegations and given what you've told me. So I'm not sure what the full story is, but given what you've told me, I can't have the two of you around each other at the present time. I mean, I don't. You're going to have to assist her in some way, Mr. McLean.
Yes, Your Honor. We'll be talking with the social worker as soon as possible.
Okay. All right. Good luck to you all. Who do we have next?
Thank you.
You're
welcome, sir.
Next, Your Honor, we're going to go to position number 3, Ms. Black.
Good afternoon, Ms. Black. Just let me address everyone that's there since I have not had the opportunity to. Good afternoon, everyone. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. You all have a right to remain silent. Anything you say can be used against you. You have the right to have an attorney present at these proceedings. If you do not have a private attorney, we are providing you with the assistance of a public defender this afternoon if you choose to utilize their services.
Why you
Ms. Black, you've been charged in case 24 CR 006365C with simple battery family violence and battery family violence. Is there a history, Ms. Washington?
No, Your Honor, this is a defendant's first arrest, and the defendant does meet the criteria for UJR jail. Nothing further.
Yes, Ms. Allen?
Thank you, Your Honor. This is an incident that occurred yesterday on the 8th of September. At about 1:30 p.m., police were called in Roswell to 218 Mill Creek Place. There they spoke to the victim. His name is Salman Muhammad, and then that's spelled S-A-L-M-A-N, first name. He reported that he'd been pushed multiple times during an argument with the defendant, and she was preventing him from getting past. The victim was actually seen to have dried blood around his nose area and fresh scratch marks on his neck. The defendant admitted to police that she was very angry and that she tried to prevent the victim from leaving, and push the victim, instigating the incident. We'd asked for a $1,000 SOB through pretrial. This is her first arrest. We have tried to get in touch with Mr. Muhammad this morning, but have not been successful yet. We'd ask for no contact, no drugs, alcohol, or weapons, and stay away from the location at 218 Mill Creek Place until the further issues around contact can be addressed. Thank you.
Okay. Mr. Muhammad is on the line and wishes to address the court. Now is your opportunity to do so. Yes, Mr. McLean.
Your Honor, that's acceptable to the defense. She will find a place to go and update her address as needed. She has family here, so she should be fine.
Okay, for the simple battery, it'll be $1,000 signature bond through pretrial level 1. For the battery, a $2,000 signature bond through pretrial level 1 makes for a total of a $3,000 signature bond through pretrial level 1. No further contact with Mr. Muhammad. Stay away from the Mill Creek Place address. She can go back to that address on one occasion with law enforcement to retrieve any belongings that she might have there. No drugs, alcohol, weapons while out on bond. Good luck to you, ma'am.
Next, Your Honor, we have position number 4, Ms. Tammy Bursack, and I believe she has private counsel.
Okay, is anyone on the line that's representing Ms. Bursack? Who would the private counsel be? Do we know, Norris?
Who's your attorney?
His first name is Ben. He was set up through Doug Chalmers. So
You got to tell the judge. Yeah, just talk loud.
it was set up last night. His first name is Ben. I don't know what his last name is. It was set up through another attorney, Doug Chalmers. And I haven't spoken to anyone today, so I don't know if they've been made aware. Originally, they said it would happen at 11:30 today.
Your Honor, I'll have her talk to Mr.
Hey,
Okay, thank you.
I just jumped on this damn Zoom meeting.
Okay, listen, if y'all,
You wanna get on? You wanna see?
Ms. Grisham, you can all hear.
I don't know. I don't know what she looked like.
Can we get them muted, please? Thank you. Okay, Norris, who do we have next?
We're gonna go to position number 6, Ms. Coleman.
Okay. Good afternoon, Ms. Coleman. You've been charged in case 24 CR 006347Y with criminal trespass, battery family violence, hindering a person making an emergency telephone call, and cruelty to children in the 3rd degree. Is there a history, Ms. Washington?
Yes, Your Honor, this is a defendant's second arrest. The last arrest was in August of last year for battery, family violence, cruelty, 3rd, and hindering a person from making a phone call. No disposition was listed. The defendant does meet the criteria for level 2 with exception to any bail restricted charges.
Were those Fulton County charges, Ms. Washington?
I believe it was Union City, but there was nothing that was listed. I can't remember right offhand. But I checked Odyssey and I didn't see it in our system.
Okay, Ms. McConkey?
Yes, Your Honor. The incident location for this incident is 7220 Oakley Road in Union City. The victim in this case is Christian Rutledge, who shares a child with the defendant. The defendant is accused of coming to the victim's residence and trying to kick his front door in. The victim was holding the door to prevent the defendant from entering the home, which caused him to receive a cut on his arm and his finger. The defendant is also accused of preventing the victim from being able to call 911 by snatching the phone out of his hand. All of this did occur in the presence of the party's 4-year-old son, and the victim's door was damaged as a result of the incident. Our office has spoken with Mr. Coleman. Sorry, not Mr. Coleman, with Mr. Christian Rutledge, the victim in this case, who stated that him and the defendant are not in a relationship. They don't live together, but they do share that one child. He states he no longer lives at the incident location, that the defendant was dropping their child off and became upset because he was on the phone with another woman. As she was trying to get inside the home, he was trying to keep her out, just as it's stated in the warrant. He states that they've been in contact since this incident and there has been no violence since then. He states he wants no violent contact. So based on that, the state's recommendation is going to be no further violent contact with the victim, anger awareness, no drugs, weapons, or alcohol, and a signature bond through pretrial services. It looks like, because the charges from the 2023 arrest are the same as these charges here, and they occurred in Union City. So I'm wondering if it's the same charges, but I will need to take a look at that.
Judge, I've already been to jail on these charges. I've already been released on a signature bond for these exact same charges. I went to court for them in Union City, but I pled not guilty, so Union City was like they would bond it over to Atlanta. I never got anything in the court. I got pulled over the other day and they told me that I had an active warrant for these exact same charges.
Okay, so we're gonna, Mr. Cook, this is your, this
Yes,
is your,
Your Honor.
any
And I-
objection to, anything that the state has recommended?
Nothing, Your Honor.
Okay.
No objection, yes.
All right, so I'm gonna give her a signature bond through pretrial level 1 and all the charges. 500 for the criminal trespass, 1,500 for the battery, 500 from the hindering a person making an emergency phone call, 500 for the cruelty. Makes for a total of $3,000 signature bond through pretrial level 1. No further violent contact with Mr. Rutledge, and no drugs, alcohol, or weapons while out on bond.
Thanks, Your Honor.
Good luck to you, Ms. Coleman.
Next one is gonna be position number 10, Ms. Ford.
Good afternoon, Ms. Ford. You've been charged in case 24 CR 006350G with theft by deception. Is there a history? Ms. Washington?
Yes, Your Honor. This is the defendant's 10th arrest. The last arrest was in September of last year for theft by shoplifting, which appears to be open. There's a 2013 misdemeanor conviction for theft by shoplifting, a 2015 arrest for theft by shoplifting, and no disposition was listed. In 2016, there was a misdemeanor conviction for 3 counts of theft by shoplifting, and the defendant does meet the criteria for level 1. Nothing further.
Ms. McConkey?
Yes, Your Honor. I also charged the defendant with theft by shoplifting, but I think she might be having the same issue as Ms. Ashley Bell, which is that that case is still linked to the magistrate court, and so it needs to be unlinked. But for the theft by deception, she is accused of fraudulently returning $79 worth of items that she did not buy to the Target located at 3535 Peachtree Road in Atlanta. She went to that Target, took items, put them in a Target bag, acting like she had bought them earlier, and then used an old receipt to try to return them. And that's how she got the $79 in cash. I don't know if we can do the theft by shoplifting, considering that it is still linked to magistrate court, so there's no accusation number. But given the facts that she has her history has numerous theft by shoplifting arrests and some convictions, the state's recommendation is going to be $1,000 surety bond, stay away from all target locations, no drugs, weapons, or alcohol. And the theft by shoplifting was from the same target.
That's my
Ms.
case.
Bridge-
Your Honor. That's my
Ms.
case. Your
Bridge-
Honor.
Okay, hold on. I need to, since there's not an accusation drawn for the theft by, I don't want her sitting in jail on a theft by shoplifting that she doesn't have a bond on. Ms. Bridgewater? Are you with me?
I am, Your Honor.
Okay, I just want to make note that we'll need, are you gonna try to file that down, Ms. McConkey? What are we doing with that?
Yeah,
theft by-
I filed them down, but I guess even though I filed them down because it's still linked to magistrate court, an accusation won't come through and I can't unlink it from the magistrate court.
Do we know what can be done, Ms. Bridgewater?
I will check on it, Your Honor. Michael isn't here today, but I will check on it. If worst case scenario, we'll just have to go through with the theft by deception.
I believe that's part of the issue on a couple of these cases today, Your Honor. Linking the charges has become an issue and it prevents us from being able to file an accusation.
Okay, I just want to make sure that these people
know.
are not kept in jail because of something that so what you're telling me is that if I just give her a bond on the theft by deception, that the fact that she has something else linked is not going to keep her in custody? Is that correct or not? Does anybody know?
Your Honor, as far as I know, that the information based on how the jail puts people in, magistrate court cases get linked. And then it's a clerk and jail function, I believe, that unlinks them so that we can file the accusation.
Okay.
Your Honor,
So-
my concern would be getting the theft by deception bond, and I understand their problem with the linkage. That's not their that's somebody else's bailiwick, and they're struggling with it. But what if an hour later, then the shoplifting's unlinked, and
No, we're just going through the.
here they are again?
But no,
So
that's
looking
not
at the jail screen, sorry to interrupt, she is being held on both charges and the theft by shoplifting, she has a $2,000 bond.
$2,000
A $2,000 surety bond on the theft by shoplifting.
Mm.
It's in there as a theft by taking. I changed it to a theft by shoplifting, but she does have a $2,000 bond on that charge and it's a surety bond.
Your Honor, if I may,
Yes.
can I go ahead and get the list of the cases that we're having problems with unlinking? Because we have someone who's got to do that now, so that we can not have this problem for the defendants.
Okay.
So does anyone have the list that we're having problems with? Can they get it to me so that?
Yes, I just sent you a message on the other case that I have that I believe
Okay,
has the
are there
same
any
problem.
others by anyone else?
Ashley Bell is my client. This is Alvin Kendall. Ashley Bell, I think you all didn't have the accusation, or she wasn't listed on the calendar. She was on.
Right. So thank you, Mr. Kendall. So if we can put that on the list also, Ms. Bridgewater.
Okay, so I have this one and I have the young lady with the mixed EU or somebody that we just,
Right.
I will do hers as well. And this one, and it's Ford. Okay.
Okay. All right. All right. Yes, Mr. Cook.
Your Honor, we have no objection to any condition of the bond. We would be seeking a signature bond at whatever level the court deems appropriate.
All right. For the theft by deception, it's going to be a $2,000 signature bond through pretrial level 2. When we get the theft by shoplifting filed, it'll be a $2,000 signature bond through pretrial level 2. Stay away from, I guess at this point in time, all Target stores, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Ford.
You don't. Next, Your Honor, we're gonna go to position number 26, Ms. Ward.
Good afternoon, Ms. Ward. You've been charged in case 24 CR 006342F with battery family violence. Is there a history?
No, Your Honor, this is the defendant's first arrest, and the defendant does meet the criteria for UJR jail. Nothing further.
Okay,
That's my case, Your Honor.
okay.
This is an incident that occurred yesterday on the 8th of September. Oh, hold on.
Yeah, I didn't find it.
Between 4 and 7 a.m., police were called to 5705 Harrier Lane. That's Harrier Lane. Mrs. Raisha Purnell, Raesha, reported that during an altercation with her stepdaughter, she was struck in the head with a broom handle. There were scratches seen on her, and she requested medical attention for bruising and swelling on the top of her head. The victim, Ms. Purnell, reported that she's married to the young woman's mother and that they had asked the young lady to leave the residence. She wasn't cleaning up after herself. There was an argument. She made threats to have people come and take care of her stepmother, Mrs. Purnell, and at that point tried to force her way into the residence. They had a physical altercation, and the defendant in front of you struck Mrs. Purnell in the head with the broomstick. This was witnessed by the defendant's mother, Samantha Ward, who was also on scene. Our office has been in touch with both ladies today, Your Honor. This is the first arrest for this young woman. We're asking for an SOB through pretrial level 1. No contact with the individuals mentioned, Samantha Ward and Ms. Purnell. Stay away from the location, and no drugs, alcohol, or weapons while on bond. Again, that's 5705 Harrier Lane. And both Ms. Purnell and I believe Ms. Ward are on Zoom. If you'd like to hear from them, if you would sound for them. Thank you.
Okay, I see you there, Ms. Purnell, and I also see you, Ms. Ward. If you would like to address the court, now is your opportunity to do so. Of course, you don't have to, but if you would like to, I'll need for you to unmute yourself, and I'll have to swear you in. So let me start with Ms. Purnell. Ms. Purnell, would you like to address the court?
Yes, I would.
Okay, do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Thank you, ma'am. What would you like to tell the court?
This was the first physical altercation, but I don't know her mental status because of she's a cutter and all of this other stuff. I didn't know what to do or handle the situation. As me and my wife talked yesterday, it's hard to be a mother and have your wife and have this type of thing happen in your home. But me and her mother both agreed that we don't want her at the house because it's causing different things to happen. We don't like no messy house, and then trying to have traffic and stuff through the house. We both agreed that we would not like her there, but my wife has the choice to speak to herself. I just don't want contact with her.
Okay, thank you for being here this afternoon, Ms. Purnell.
Thank you.
Now, Ms. Samantha Ward, if you would like to address the court, you'll have to unmute yourself for me, ma'am.
Okay. Yes,
Okay, so if you could raise your right hand for me. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. What would you like to tell the court, Ms. Ward?
I would like for her to stay elsewhere at this moment. She doesn't listen to anything that I have to say in the household, and yesterday was uncalled for.
Okay, thank you for being here this afternoon, ma'am.
Yes, sir.
Afternoon, Ms. Holly. Is this your case?
This is my case, Judge. Good afternoon. Obviously, I don't have any objection to the signature bond, and I don't have any problem. And after talking with Sport Ward, neither does she, with her not going back to the residence. We would like for her to be able to have contact with her mother, as she does help her with medication. But we don't have any problem with a stay away from the residence and a stay away from Ms. Purnell. As for her stuff is still there. She has been residing there, so we would ask for a one-time police escort so she can go back and get her stuff.
Okay. It'll be a $2,000 signature bond through pretrial level 1. No further contact with Ms. Purnell. Stay away from the 5705 Harrier Lane address. She can go back to that address on one occasion with law enforcement to retrieve any belongings. No drugs, alcohol, or weapons while out on bond. Good luck to you all. And let me just say while I'm in a break here, whoever's the Zoom user there, this is a court session. We are in court. I don't want to see you eating. I don't want to see you moving around. I don't want to see you doing any other business on camera before this court, and I don't want to have to tell you that again. So if you're on Zoom or if you're in your home or wherever, we're happy to have you, but please treat yourselves as if you are in a courtroom with me, okay? Who do we have next, Norris?
It's gonna be position number 27, Mr. Christopher Whitaker. There you go, ready? Whitaker, let's go.
I'm here. Your Honor, are we finished with Ms. Bell?
No, we're not finished with Miss Bell. I'm waiting for them to file the charges down so I can address her.
Okay.
Okay.
I'll go after Mr. McLean's client, Your Honor.
Good afternoon, Mr. Whitaker. You've been charged in case 24 CR 006362F with criminal trespass and willful obstruction of law enforcement officers. Is there a history, Ms. Washington?
Yes, Your Honor. This is the defendant's 8th arrest. The last arrest was August 14th of this year for disorderly conduct, and it does appear that the defendant is currently on probation for that case. There was a 2014 misdemeanor conviction out of Florida for possession of drug equipment. No felony convictions were listed, and no criminal trespass arrests were listed. The defendant meets the criteria for level 2. Nothing further.
Okay.
Thank you, Your Honor. That's my case. You may remember, I'm not sure if you were present for this one, but this gentleman just came through first appearance in SAP in August. He pled guilty to disorderly conduct for making threats to the leasing agents at his apartment complex in August on the 13th. And on August the 27th, he pled guilty and is now on probation. I believe there was an MH issue that was raised during that first appearance. And so the state's requesting a MHET as it relates to the bond hearing here today. This is a criminal trespass incident from 369 Morosco Drive. That's Morosgo. That's a Chevron gas station, Your Honor. The defendant had been criminally trespassed at around 8 a.m. that morning. The clerk there called the police and reported that he was panhandling, making customers uncomfortable, blocking the entry. Police criminally trespassed the gentleman, and then he returned at about 1 p.m. sitting on the ground there in front of the entrance at the location. Police approached him and told him that he needed to leave and reminded him that they'd spoken to him previously, and he became aggressive. Asked police to shoot him and then wouldn't comply with commands. He refused to put his hands behind his back to be detained. So we're asking for a $2,000 surety, Your Honor. MHET, stay away from the location at 369 Morosco Drive, and no drugs, alcohol, or weapons. Thank you.
You wouldn't happen to have the sentencing sheet, would you, Miss Allen?
I can absolutely pull it up.
Okay, because I want to know if I was the one and if and what.
Let me look at my notes.
Conditions. Okay, I appreciate it. Thank you. Yes, Mr. McLean.
Your Honor, in all candor to the court, what is being proposed is completely logical, and MHET is needed.
Okay. So he'll be back on the SAP calendar on September 24th. So for each charge, it'll be a $500 good bond, makes for a total of $1,000 good bond. Stay away from the Chevron on Morosco Drive and MHET, and no drugs, alcohol, or weapons. Given that, Miss Allen, you don't have to get the sentencing sheet for me.
Thank you.
Okay, and we'll see, let me see.
Joy, get the baby.
We're trying to figure out. We're trying to figure it out. for you.
Mr. McLean,
Yes,
Mr.
sir.
McLean, I will be handling that SAP calendar on the 24th. So I'll remember this gentleman, and if you can just have somebody report to me at that time, I'd appreciate it.
Very good. So.
Thank you.
Your Honor, what was the bond amount? I'm sorry.
You're fine. It's $500 good on each charge, so $1,000 good.
Thank you.
You're welcome.
Great.
Okay, where do you want to go next?
Next,
ACD,
go ahead, Milton.
thank you. ACDC, position number 7, Ms. Curtis.
Okay. Good afternoon, Ms. Curtis. You've been charged in case 24 CR 006348Y with giving false information to law enforcement and driving while your license was suspended or revoked. Is there a history, Ms. Washington?
Yes, Your Honor, this is the defendant's 4th arrest. The last arrest was in December of last year for driving while license suspended or revoked. In 2022, there was an arrest for driving while license suspended or revoked, but there is no disposition listed. The defendant does meet the criteria for UJR jail. Nothing further.
Ms. McConkey?
Yes, Your Honor. Officers were dispatched to the incident location, which I believe is the Lowe pawn shop, in regard to a suspicious person. When they made contact with the defendant and asked for her identifying information, she gave the false name of Shernika Curtis and the false date of birth of July 25th, 1995. The defendant's license is also suspended and revoked, and she is accused of driving with no valid license. The state's recommendation is going to be a signature bond, no driving without a valid license, stay away from that incident location, no drugs, weapons, or alcohol.
Okay, I'm not sure, is this your case, Mr. Cook?
Yes, it is, Your Honor.
Okay, you're not on camera, I just want you to know.
Okay.
Any objection to any of the state's requests?
No objection, Your Honor.
All right, so for each charge, it'll be a $500 signature bond through the jail, makes for a total of $1,000 signature bond through the jail. Stay away from the incident location, no driving without a valid license, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Curtis.
Your Honor, next is going to be position number 11, Mr. Graves, Solomon Graves.
Okay, and Norris, I don't know if you saw the message on position number 4. Ms. Bursack does have an attorney that has joined us.
Great, thank you, Your Honor.
You're welcome. And tell me again, what position is this?
This is position number 11.
Number 11, thank you, I'm sorry. Mr. Graves, good afternoon. You have been charged in case 24 CR 006351B with battery and theft by taking. Is there a history, Ms. Washington?
Yes, Your Honor, this is the defendant's 5th arrest. The last arrest was in 2019 for robbery, and the defendant was convicted of that in Florida. There was a 2007 felony conviction for 2 counts of armed robbery, a separate 2007 felony conviction for possession of a firearm and armed robbery. The defendant does meet the criteria for level 2 with the exception to any bail restricted charges.
Okay. Mr. Cook?
Oh, this is my case, Your Honor.
Oh, I'm sorry.
No, this incident occurred at 3200 Lakeview Place in Atlanta. The defendant is accused of striking Matthew Wilson several times until Mr. Wilson fell to the ground, causing visible injuries to Mr. Wilson's face, hand, and elbows after the parties had a verbal dispute. The defendant is also accused of stealing Joshua Patterson's PlayStation 4 and the accompanying joysticks. Based on the defendant's history, the state's recommendation is a $1,500 surety on the battery, a $500 surety on the theft, no further contact with the victims, stay away from the incident location, anger awareness, and no drugs, weapons, or alcohol. I would ask the court to sound for Mr. Matthew Wilson and Mr. Joshua Patterson.
Mr. Wilson or Mr. Patterson, if you're on the line and wish to address the court, now is your opportunity to do so. Doesn't appear so. Mr. Cook?
I believe this case was a conflict, Your
This
Honor.
is, Your Honor, this is Ms. McLeod's client.
Oh, okay. Yes, good afternoon, Ms. McLeod.
Afternoon, Your Honor. Which one of my clients is this?
Position 11, Mr. Graves.
Yes. I did not hear what pretrial said concerning his history.
Ms. Washington, would you be able to give the history for Ms. McLeod, please?
Yes, this is the fifth arrest. The last arrest was in 2019 for robbery, and the defendant was convicted of that in Florida. There's a 2007 felony conviction for 2 counts of armed robbery, a separate 2007 felony conviction for possession of a firearm and armed robbery, and the defendant meets the criteria for level 2.
Thank you. Your Honor, my client is 34 years old. He is not in a position to pay for bond, so I would ask the court to consider giving him a signature bond. He also tells me that the alleged victim in his case is now deceased, which would make a difference with the state going forward on this case. I don't have any means of verifying that at this time, but this is what he informed me, Your Honor.
Okay. Your client has his hand up, Ms. McLeod. Do you want to, Mr. Graves, you have a right to remain silent. Anything you say can be used against you. Do you want to address him, Ms. McLeod?
Mr. Graves, is there something in particular that you want?
Can you hear me?
I can hear you.
All right, well, good afternoon to all y'all. Listen, first of all, I'm wrong for what I did. It was about a game system. We was all.
No. Listen, Mr. Graves, you have the right to remain silent. This is not your trial. This is just about a bond.
Okay, I can't afford no bond. I'm working. My daughter.
That is what I was. Mr. Graves, let me speak to the judge. You and I spoke earlier, and I understand your situation that you cannot afford a paid bond.
I'm gonna lose my job. Get help.
All right, so for the battery, it'll be a $4,000 signature bond through pretrial level 2. For the theft, a $1,000 signature bond through pretrial level 2 makes for a total of a $5,000 signature bond through pretrial level 2. No further contact with the alleged victims. Stay away from the incident location. No drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
You're welcome. Good luck to you, Mr. Graves.
Your Honor, next is position 15, Ms. McLeod's client.
Okay. Good afternoon, Ms. Hollins. You've been charged in case 24 CR 006355J with battery, willful obstruction of law enforcement officers, and simple assault. Is there a history, Ms. Washington?
Yes, Your Honor. This is the defendant's 33rd arrest. The last arrest was in June of this year for a probation violation in Cherokee County. There was a 2011 misdemeanor conviction for battery in Cobb County, 2012 misdemeanor conviction for simple battery also out of Cobb County, 2013 felony conviction for theft by receiving stolen property, 2014 felony conviction for possession of meth, 2014 misdemeanor conviction for violating a family violence order out of Cobb County, 2018 felony conviction for ID theft, 2019 misdemeanor conviction for battery, and the defendant was also arrested for simple battery but pled no to the simple battery, and that was out of Clayton County. A 2020 arrest for simple battery, no disposition was listed. 2024 felony conviction for criminal damage to property in the second degree, 2 counts of battery, 2 counts of criminal trespass and willful obstruction. The defendant is currently serving a 5-year sentence on probation for that case out of Cherokee County. a 2024 felony conviction for aggravated assault, terroristic threat, and criminal trespass, and that is 4 years on probation, and that case is out of Fulton County. The defendant does meet the criteria for level 3. Nothing further.
Ms. McConkey?
Yes, Your Honor, this incident occurred on the 18th of August. The incident location is 3257 Main Street in College Park. The defendant is accused of striking a Mr. Andre Dox multiple times, causing multiple bleeding lacerations to the victim's head. The defendant also threw a rock and a traffic cone at the victim. All of this was on footage from the store nearby, which I believe is a Marathon gas station. The defendant did attempt to flee several times while officers were attempting to detain her. And while officers were attempting to detain the defendant as she was fleeing, the victim, Mr. Andre Dox, left the scene. However, the officer did know who the victim was because she had previously had an encounter with him. Multiple witnesses also state that the defendant stabbed the victim, but officers were unable to find him after he left. To be noted, when officers did arrive at the scene, they did observe the defendant trying to initiate another altercation with a different man, but that man was able to walk away before it escalated further. Based on the defendant's criminal history, which includes numerous violent arrests and convictions, there is a great chance that she will reoffend and possibly intimidate this victim as well. So the state's recommendation is going to be a $2,500 surety bond on the battery, a $1,000 surety bond on the willful obstruction, a $1,500 surety bond on the simple assault, no further contact with Andre Dox, stay away from the incident location, anger awareness, no drugs, weapons, or alcohol. I'm not sure if a BHET or MHET is necessary in this case, but I suspect that something else might be going on here based on her history and the facts of this case. It doesn't appear that she even knew this man. Nothing further, Your Honor.
Mr. Dox is on the line and wishes to address the court. Now is your opportunity. Ms. McLeod?
Yes, Your Honor, my client is 33 years old. She is the mother of a 4-year-old child. She is currently not in a position to pay for bond, Your Honor. She is not employed outside of her home. Based on my conversations with her, she tells me that she was actually attacked by this person and she was simply defending herself. She also tells me that the police officers essentially mistreated her when they were arresting her. So she expressed some concern about that, Your Honor. But I would ask the court to give her a signature bond at the level recommended by pretrial. Otherwise, she's going to be sitting in jail because she does not have the means to pay for bond. Nothing further, Your Honor.
For the battery, it'll be a $1,000 good bond. For the obstruction, a $500 good bond. For the simple assault, a $500 good bond. Makes for a total of a $2,000 good bond. No further contact with Mr. Dots, no drugs, alcohol, or weapons while out on bond.
Your Honor, will you repeat that, please?
Yes, ma'am. 1,000 for the battery, 500 for the other two. Makes for a total of a $2,000 good.
Thank you.
You're welcome. Good luck to you, ma'am. Who do we have next?
Next, Your Honor, is going to be position number 4, Ms. Tammy Bursack.
Okay, good afternoon again, Ms. Bursack. You have been charged in case 24 CR 006363B with battery family violence. Is there a history, Ms. Washington?
This is the defendant's first arrest. No criminal history was on file, and the defendant does meet the criteria for UJR jail. Nothing further.
Thank you.
Your Honor. That's my case. This occurred yesterday on the 8th of September at about 4:20 in the afternoon. Police were called to 7095 Sweeten Creek Road in Johns Creek. There they met with the defendant and her spouse. The victim in this case, Michael Byman, Byman, B-Y-M-A-N. Mr. Byman was observed to have injuries. He got a bloody nose and a cut to his lip, I believe. Mrs. Bursack reported that her spouse has a drinking problem and she had seen him drinking in his vehicle in the parking lot, which is what he does when he doesn't want to hear her yell at him. She went over and tried to take his keys from him. This is also a common occurrence. They struggled over the keys. She had tried to park her car in front of his to prevent him from leaving. And she admitted that there was a struggle and that she struck the defendant in the face. I believe she was also struck as well. She has no prior history, Your Honor. I believe the victim, Mr. Byman, is on Zoom. Based on the fact that there are no prior history here, we're asking for an SOB through the jail, but a requirement that there be no violent contact. Obviously, we can't request that the defendant abstain. I mean, we can, but it's not her drug or alcohol issue that seems to be the problem here. So my understanding is that that's going to be addressed, and that's the state's hope. Thank you.
Mr. Byman is on the line and wishes to address the court. Now is your opportunity to do so.
Your Honor, I'm Benjamin Alper. I have spoken with Mr. Bynum and I represent his wife. He is on the Zoom, but he has authorized me to convey to the court that he has no objection to a bond or the state's condition of no violent contact. There are some issues going on that he needs to resolve. He absolutely wants her home and has no objection to the state's recommendation.
Okay, thank you, Mr. Alper. It will be a $2,000 signature bond through pretrial level 1. No further violent contact with Mr. Byman, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Bursack.
Thank you, Your Honor.
Anything further this afternoon, Mr. Alper?
No, Your Honor, if that's all right, if I can be excused, that would be great.
Yes. Have a good afternoon.
Thank you, sir. You too. Thank you.
Next,
Who do
we
we have?
have position 19, Your Honor, at ACDC.
Okay.
And her attorney is Thomas Salata.
Good afternoon, Your Honor. Nice to see you.
Nice to see you also, counsel. Good afternoon. Good afternoon to you also, Ms. McGurk. You have been charged in case 24 CR 006358J with battery, criminal trespass, and 2 counts of battery. Is there a history, Ms. Washington?
Yes, Your Honor. This is the defendant's 7th arrest. The last arrest was in 2022 for cruelty. In 2020, the defendant received first offender treatment for burglary in the first degree, and the defendant is currently serving a 5-year sentence on probation for that case. In 2020, there was an arrest for 2 counts of simple battery and no disposition was listed. There was also a 2022 arrest for battery family violence, which appeared to be dismissed in Fulton County. The case number is 22 CR 002658C. And also in 2022, the defendant received first offender treatment for cruelty in the second, which appeared to be reduced to reckless conduct, and that was sealed in 2024. The defendant does meet the criteria for level 2. Nothing further.
Thank you.
And that's my case, Your Honor. This is an incident that occurred at 265C Holly Circle in Roswell. That is the home of Patricia Matyi, Matyi is how you spell the last name. She is related to the defendant in that the defendant has been in a relationship with her son. So this case is the result of the defendant going over to that location after being criminally trespassed from that location in 2022 in order to visit the young man that she was in a relationship with for a period of time. The victim, Mrs. Matyi, reported that she came home to the location and the defendant was there present and invited over to the location. She acknowledges by her son. She reported that there's an MH issue, that they've had to have her 1013'd in the past, and has requested help with that. We're asking for a MHET, Your Honor. Mrs. Patricia has requested no contact and obviously a stay away order from that location. We also spoke with the other named victim, her son, Adam, the former boyfriend of this defendant, who reports they are no longer in a relationship, but confirmed the events in the warrant. She was seen to be repeatedly punching him in the face after she came over to visit and engage with him in some contact. He was seen to have bruising all over his face as well as a bloody nose. It was when his parents returned home that the defendant became violent. He also is requesting no contact, Your Honor. The criminal history for this young woman includes only cases against her family members. Her battery family violence case in 2022 that was eventually dismissed was an assault on her father, Sean. She had a first offender disposition in Superior Court for an aggravated assault that eventually was allowed to plead down to burglary and a felony terroristic threats, where she entered into a residence and assaulted people inside. Again, this was a messy relationship situation. And then the reckless that she's now on probation for as a first offender was related to the cruelty in the second degree, which would be negligence as it relates to her own child. So there appears to be an issue here with MH, and that's why we're requesting a evaluation as part of our bond, Your Honor. We'd ask for a $3,000 surety just based on the history and behavior. Stay away from the location. Again, that's 265C Holly Circle in Roswell. And no contact with Miss Patricia or Adam. Last name for both of them is Matyi, M-A-T-Y-I, and I apologize if I'm saying that wrong. I do not believe they're here on the Zoom, Your Honor, if you would just sound for them. Thank you.
If Patricia or Adam Matyi are on the line and wish to address the court, now is your opportunity.
They are not, Your Honor.
Okay, good. Yes, Mr. Solano.
Thank you, Your Honor. May it please the court. Thank you, ASG Allen. I have the honor and privilege of again representing Tina McGurk, Your Honor. She's 33 years of age. She's the single mother to 2 children, 3 and 5, both boys. She resides with her parents, Mr. and Mrs. McGurk, who've resided in Roswell for over 30 years. She does have a history, we acknowledge, and it would take issue with some of the representations because I was there representing her. But the fact of the matter is, Your Honor, is that she has never failed to appear for court. She has been reporting to probation satisfactorily. She does not use controlled substances of which she does not have a prescription. She does not consume alcohol. The children are in the possession of her mother and father right now, the grandparents who are older, and she also holds and maintains a full-time job with the Ameris Bank Amphitheater here in Alpharetta, the street from her house, where she works in guest relations. We would oppose a mental health evaluation. We don't think it's needed in this case, Your Honor. I did speak with both Patricia Matyi and Adam Matyi, and we are not opposed, and they would like a no contact provision and a stay away from their house provision. We don't have any problem with that because basically what happened was he came and Adam came, picked her up, brought her home, and when mom came home, she had a problem with it. So good idea for us to stay away from there. We don't have any problem with that, Your Honor. Respectfully, we would ask the court to grant bond in this case. I'll be representing Ms. McGurk as I have previously throughout this process. I look forward to getting some help on the outside. I have been in contact with a mental health provider who is ready to see her under her private insurance this week. Respectfully, again, Your Honor, we would ask she be admitted to bond. She's never missed a court date.
Okay. For each of the batteries, it'll be a $2,000 signature bond through pretrial level 2. For the criminal trespass, $1,000 signature bond through pretrial level 2, makes for a total of a $5,000 signature bond through pretrial level 2. No further contact with Adam or Patricia Matyi. Stay away from the C. Holly Circle address. No drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
You're welcome. Good luck to you, ma'am. Anything further this afternoon, counsel?
No, Your Honor, may I be excused?
Yes. Have a good rest of your day. Thank you.
It's an honor to see you. Thank you.
Next, Your Honor, we're going to go to position number 13. Mr. Hardaway?
Okay. And Officer Milton, I don't know if you saw in the chat, but they have filed down the charges for Ms. Bell, so we'll be ready to proceed on Ms. Bell when you all are ready. Good afternoon, Mr. Hardaway. You have been charged in case 24 CR 006354A with 2 counts of battery family violence and simple assault family violence. Is there a history, Ms. Washington?
Yes, Your Honor. This is the defendant's second arrest. The last arrest was in 2012 for theft by taking, which appeared to be no prize. The defendant does meet the criteria for UJR jail.
Yes, Ms. McConkey.
Yes, Your Honor. This incident occurred on the 8th of September at 324 Riverview Court in Fairborn, Georgia. The defendant is accused of threatening to shoot his mother, Carnetta Frazier, after they had a verbal dispute regarding his phone. The defendant then began reaching for a can of WD-40, and that is when Darius Lemon and Jay Hardaway intervened, and Mr. Lemon was bitten in the arm by the defendant. The bite did break Mr. Lemon's skin and caused Mr. Lemon to bleed. The defendant is also accused of pulling out Mr. Lemon's dreads. A witness to the incident by the name of Jay Hardaway corroborated the fact that the defendant was the primary aggressor, and he also stated that the defendant had been consuming alcohol the night before and the morning of the incident. We have had an opportunity to speak with Mr. Lemon, who stated that him and the defendant are brothers. They live together at the incident location. He did confirm the events in the warrant and stated that they had gotten into altercations in the past, but never to this extent. He does not want any contact with the defendant and wants him to stay away from the residence. The state's recommendation is a signature bond through pretrial services, no further contact with Darius Lemons or Carnetta Frazier, stay away from the incident location, anger awareness, and no drugs, weapons, or alcohol. At this time, I would ask the court to sound for Mr. Darius Lemons and Ms. Carnetta Frazier.
Ms. Frazier or Mr. Lemons is on the line and wishes to address the court. Now is your opportunity. Hey, Ms. McLeod, is this your case?
Your Honor.
Okay.
My client is 37 years old. As pretrial has stated, he doesn't have a record. He tells me that he's been living at this location with his family, with his mother specifically, that he pays rent there. His mother decided that she wanted him to leave and was trying to illegally evict him. She also tried to take his phone away from him. He tells me that he was essentially jumped by his other brother and someone else, and he was just trying to defend himself. But all of this arose out of a situation where they were trying to say, you have to get out without going through the proper procedure to evict him, Your Honor. I would ask the court to give my client a signature bond through the jail, as he obviously has no kind of record, and his narration of the facts differs significantly from what is being alleged in the warrant, because they're trying to say he was the aggressor when he's telling me that essentially 3 people jumped on him. Well, he didn't say his mom jumped on him, but she tried to take his phone away from him to prevent him from calling, because he had tried to call the police. Nothing further, Your Honor.
Okay, so for each of the batteries, it will be a $2,000 signature bond through pretrial level 1. For the simple assault, $1,000 signature bond through pretrial level 1. Makes for a total of a $5,000 signature bond through pretrial level 1. No further contact with Ms. Frazier or Mr. Lemons. Stay away from the Riverview Court address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. No drugs, alcohol, or weapons while out on bond. Good luck to him.
Your Honor, can we go back to Miss Ashley Bell, please?
Yes. Good afternoon again, Ms. Bell. you have been charged in case 24CR006366A with battery family violence. Were you able to pull a history, Ms. Washington?
Yes, Your Honor, this is a defendant's first arrest. The defendant does meet the criteria for UJR jail.
Okay, Ms. McConkey?
Yes, Your Honor, this incident occurred September 7th at 1215 Woods Circle in Atlanta. Officers arrived at the incident location in response to a domestic dispute call. The defendant was visibly intoxicated at the time, was slurring her words, and officers did smell the heavy stench of alcohol on her person. The defendant is accused of hitting the victim in the head with her cell phone after he attempted to take their daughter to his mother's house since the defendant was drunk and had upset their minor child. The victim did have a red scratch on the back of his head. The defendant states that she was defending herself from the victim and she did have some scratch marks on her neck, but officers stated that the story that she told them didn't really make sense in conjunction with the injuries that she had. Our office has had a chance to speak with the victim in this case, Mr. Kevin Edwards, who states that him and the defendant are married, but they're in the process of getting a divorce. They both live together at the incident location and they do share that one child. He confirmed the events in the warrant and stated that nothing like this has ever happened before. He's not in fear of the defendant and wants no violent contact. He is planning to leave the residence and the defendant can return. The state's recommendation is a signature bond through pretrial services, no further violent contact with the victim, anger awareness, and no drugs, weapons, or alcohol while out on bond. I would ask the court to sound for the victim, Mr. Kevin Edwards.
If Mr. Edwards is on the line and wishes to address the court, now is your opportunity to do so.
Your Honor, Mr. Edwards is here in my office with me today.
Okay, very good. Go ahead, Mr. Kendall.
Your Honor, I represent Ms. Bell. She's 40 years old, and as the state has told you, Mr. Edwards and Ms. Bell have a 2-year-old daughter. Ms. Bell is a stay-at-home mother. Mr. Edwards does not have any problems with her returning to the home. This was out of the ordinary one-time event. My client has admitted that she had consumed a little bit too much alcohol on that occasion. Mr. Edwards has told me that he was trying to take his daughter over to his mother's house because he had to go to work and that his wife had a little too much to drink when the arguments started. So we would ask the court to allow her sign on bond so she can come back and help Mr. Edwards with the 2-year-old child. And we're okay with the no violent contact, but they have no problems and still residing there in the home we are.
Okay. As such, it'll be a $2,000 signature bond through pretrial level 1. No further violent contact with Mr. Edwards, and no drugs, alcohol, or weapons while out on bond. All
Thank
right.
you, Your Honor.
You're welcome. Good luck to you all.
All right. Thank you, Your Honor.
You're welcome, sir.
Yeah, that's all I have for the court today.
We'll see you next time, Mr. Kendall. Yes, have a good afternoon.
Thank you.
Who do we have next?
This is gonna be position number 21, Mr. Eddie Scott.
Good afternoon, Mr. Scott. You have been charged in case 24CR006359E with 2 counts of battery family violence. Is there a history, Ms. Washington?
Yes, Your Honor, this is the defendant's 7th arrest. The last arrest was in 2019 for an FTA. There was a 2006 arrest for aggravated assault, which appeared to be dismissed. A separate 2006 arrest for 2 counts. Simple battery, which
Hold
was
on, Mr. Scott. Go ahead, Ms. Washington.
Okay, I'm just gonna start over. 2006 arrest for aggravated assault, which was dismissed. A 2006 arrest for 2 counts of simple battery, which appeared to be dismissed. And a 2011 arrest for battery, which also appeared to be dismissed. The defendant does meet the criteria for level 1. Nothing further.
Ms. McConkey?
Yes, Your Honor. This incident occurred at the Embassy Apartments located at 3300 College Street in College Park. Officers were dispatched to the location in reference to a domestic call. The victim, Bianca Duvall, stated that the father of her child, the defendant, struck her in the head, punched her ribs, and scratched her. Officers did note a laceration on the victim's head and scratches to her chest, as well as swelling around her nose. Our office has had a chance to speak with the victim, who confirmed that her and the defendant are in a relationship. They live together at the incident location and they share one child. However, she denies the events in the warrant and states the defendant did not hit her and she did not sustain any injuries. She stated that her and the defendant were in an argument and she called the police because she wanted him to leave. She states the defendant has never been violent with her in the past and that she is not in fear and wants to continue contact. Obviously, this is a different story than what she told the officers when she called and told them that he had hit her. The officers also did note with their own eyes that she had injuries. So someone did hit her.
I never lie about none of
Okay,
that. I called and
ma'am, we don't do that in this court, okay? I will hear from you in turn, but you just don't jump on and start talking. So when you do come on, you apologize to Ms. McConkey for interrupting her. Ms. McConkey, I'm sorry. You can continue.
Yes, Your Honor. As I was stating, based on our conversation with the victim in this case, we will be requesting a signature bond through pretrial services. No further violent contact with this victim. Based on the defendant's history, I think some anger awareness might be appropriate because something did occur in that apartment that night. No drugs, weapons, or alcohol while out on bond.
Okay, if Ms. Bianca Duvall is on the line and wishes to address the court, now is your opportunity to do so.
apologize to
So
her.
I'm gonna need for you to activate your camera for me, ma'am.
I can't I'm trying to. Okay.
All right, now raise your right hand for me.
All right.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can place your hand down and you owe Ms. McConkey an apology for interrupting her.
Miss McConkey, I apologize for having the hours. They were very rude. I apologize.
Thank you, ma'am. Okay, what would you like to tell the court?
Like I stated to her earlier in the officer, I was like, I suffer from postpartum, so like I asked like really wanted just to leave, and due to the officer came out, he was just trying to separate us, but we never been in an incident like with physical, things happening. This is our first time ever like being in this type of situation. I've been dating for 5 years. We got this baby that won't stop crying about him, and like, about that, Your Honor.
Okay, Mr. Ball, thank you for being here this afternoon. Ms. McLeod, is this your case?
It is, Your Honor.
Okay,
Your Honor, I would ask the court to consider giving my client a signature bond so he can get out of jail and get back to work. I believe that was the recommendation of the state as well, and we have no objection to that, as long as it's conditioned on no further violent contact with the alleged victim, who has stated her preference, and they do share a child, as she says, a very young child. I was able to have contact with her, and she tells me that her son doesn't even go to sleep unless his father is around. She has a hard time keeping him calm unless his dad is around.
for each charge, it'll be a $2,000 signature bond through pretrial level 1, makes for a total of a $4,000 signature bond through pretrial level 1, 1-day anger awareness, no further violent contact with Ms. Duvall, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Scott. Welcome.
Next is ACDC, Ms. Wallace.
Ms. Wallace is position number 25. Good afternoon, Ms. Wallace. You've been charged in case 24 CR 006341G with simple assault family violence. Is there a history, Ms. Washington?
Your Honor, this is position 25, correct?
Yes.
Okay. This is the defendant's first arrest. No criminal history was on file, and the defendant does meet the criteria for UJR jail.
Okay, thank you.
That's my case, Your Honor. Thank you. This is an incident that occurred on the 7th of September at about 2:30 in the morning. This is actually an incident that occurred on the sidewalk as police were driving by at 3305 Bobby Brown Parkway. Officers driving by watched as the defendant got out of her vehicle and approached the victim on the sidewalk and swing at him in an attempt to strike him. Officers stopped and interacted with the individuals and detained the defendant. The victim told police, Sean Pittman is his name, Pittman, Sean is how that's spelled, that the defendant had just picked him up from a concert and they argued that they lived together, and otherwise they weren't very cooperative. This is her first arrest. We're asking for an SOB through the jail and requesting no further violent contact. We have been in touch with Mr. Pittman today. He says that they do live together, they don't share any children, and that this has never happened before. Thank you.
If Mr. Pittman is on the line and wishes to address the court, now is your opportunity. Any objection to any of the state's requests, Ms. Holly?
None at all, Judge.
I'm sorry, Judge. This is Sean Pittman. I was trying to figure out how to unmute.
Okay, so can you activate your camera for me, Mr. Pittman?
Yes, sir.
Okay, raise your right hand for me. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, sir. What would you like to tell the court?
This was a mistake, and honestly, they asked me when they called me earlier if I feared or anything like that, and there was no issue. So that's all I wanted to put out there. Thank you.
All right, thank you for being here this afternoon, sir. As such, it'll be a $2,000 signature bond through the jail, no further violent contact with Mr. Pittman, no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Wallace. You also, Mr. Pittman.
Thank you.
That was through the jail, correct?
Yes.
Next, Your Honor, is going to be position number 1, Mr. Ahmad Adan.
Good afternoon, Mr. Adan. You have been charged in case 24 CR 006364E with hit and run and following too closely. Is there a history, Ms. Washington?
Yes, Your Honor. This is the defendant's second arrest. The last arrest was in February of this year for a DUI in Gwinnett, and that case appears to be open. The defendant does meet the criteria for level 2. Nothing further.
Ms. Allen, is this your case? You're on mute.
I apologize.
No problem. Thank you.
Woo!
Back on mute though.
This is a hit and run, like you just heard, Your Honor. The incident, hold on. The incident occurred on the 6th of September, between 5:30 and 11:30 p.m. is noted on the warrants, but the body cam and the police report from Alpharetta notes that officers were on scene from about 5:55 till about 7:40. They responded to a traffic accident at the intersection of North Point Parkway and Georgia 120 in Alpharetta. Their victim, Nicholas Aguado, Aguado, reported that he'd been at a stoplight when he was rear-ended by the defendant, who was driving a 2015 white Infiniti. The victim provided police with the tag number for the defendant and reported that they'd both gotten out of their vehicles, and he told the defendant he was going to call the police to make a report. And while on the phone with dispatch, he was told that they needed to move their vehicles. And so he told the defendant they both needed to relocate to the Smoothie King parking lot, and at which point the defendant left the location. So The victims waited on scene for police. Police arrived. They got the information, description of the defendant and his car, as well as the tag information. That information was pulled. Around the same time, the defendant called 911 and said that he was driving someone for Uber and had left his information and exchanged information with the victim and that he would be back. The victim denies that that's actually what happened. Police made contact with the gentleman who had just reached out to dispatch and asked him to return to the scene. He said he couldn't because he was on his way to the airport. They called him again and explained that it was important that he return or else this was going to be a hit and run case. He said he'd be back in about half an hour. Police stopped their body cam at about 7:45 with no contact from the defendant who did not return to the scene, and he stopped answering his phone calls, and so warrant was obtained, Your Honor. So you've got in front of you a hit and run and following too closely, essentially. We'd ask for a SOB through pretrial, Your Honor. That's it. Thank you.
Mr. McLean?
No argument with that, Your Honor.
Okay, as such, for each charge, it'll be $1,000 signature bond through pretrial, level 2. It's for a total of a $2,000 signature bond through pretrial, level 2. No drugs, alcohol, weapons while out on bond. Good luck to you, sir.
Next, we have position 28, Ms. Williams.
Good afternoon, Ms. Williams. You've been charged in case 24 CR 006343F with battery family violence. Is there a history, Ms. Washington?
Yes, Your Honor. This is the defendant's second arrest. The last arrest was in January of this year for theft by shoplifting in Paulding County, and that appears to be open. There are 2 holds that were showing up on the GCIC, one from Dallas, Georgia for an FTA. The warrant date is July 18th of 2024, and one out of Columbus for contempt of court, and that warrant date is May 14th of this year. The defendant does meet the criteria for level 1. Nothing further.
Your Honor, that's my case. This is an incident from yesterday, the 8th of September at about 12:30 a.m., so right after midnight. Police were called to 760 Mount Vernon Highway Northeast. There at apartment 1023, the victim, whose name is Tiara Daniels, reported that she's in a relationship with the defendant. They live together, and that she was awakened by being struck in the face. She reports that she had a bloody injury to her lip when she spoke to police, but she reports that she lives with the defendant and they argued about what is perceived as infidelity. Police made contact with them. Both of them were on the scene. The defendant admitted that she went through the victim's phone and saw communication that made her upset, that she walked into the bedroom where the victim was sleeping and threw the phone at her, striking her in the face. Police were called by a 911 or called by someone who lives in the apartment complex and reported that 2 women were heard yelling and screaming at each other, and then it sounded like someone had just been injured. So we did speak with the victim, Mrs. Daniels. She did report that they're in a relationship and confirmed the events in the warrant. We'd ask for $1,000 surety, Your Honor. She's got an open shoplifting case in Paulding County, as well as a contempt of court that you just heard about from pretrial. We'd ask for no violent contact and no drugs, alcohol, or weapons while on bond, Your Honor. And Ms. Daniels, I believe, is on the Zoom. If you'd like to hear from her, thank you.
Ms. Daniels, if you would like to address the court, now is your opportunity to do so. I'll need for you to raise your right hand for me. The other hand. Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can place your hand down. Thank you, ma'am. What would you like to tell the court?
Yeah, basically what she said, except the only other thing that I had to add is the fact that we cannot like afford a bond right now. That's kind of like where most of her frustration came from, me like talking to other people, and we're already in like a basically a poverty situation. Like we were living in Houston for a while, and then like the storms came and we lost everything, including our home, our cars, all of our documents and stuff like that. And so we were living at the hotel that's at 760 Mount Vernon Highway at the time of the incident. And yeah, that's basically she is already under a lot of stress as we both are emotionally and mentally and stuff like that. So I guess her seeing what she saw in my phone like kind of just like set off a thing. She's not a violent person. She's never even been in a fight before. It's just like a moment of like emotional weakness, I guess. Once I spoke to her on the phone from the jail, we both agreed to like go to counseling and therapy and stuff as well as like things like that. But yeah, as far as like the bond goes, like we can't even afford our but I can't afford any other bonds. Like actually after her leaving, we had to leave the hotel that we were at, and we're currently seeking shelter still, me and the kids. So it's just a misunderstanding. I asked them not to arrest her that night, but they did because she admitted to hitting me, so they took her. But yeah, she's not a violent person. Just had a moment of weakness.
Thank you for
That's
being
all.
here, Ms. Daniels. Thank you. Mr. McLean, is this your case?
Two sentences that was broken up and I didn't quite catch, but the gist of my argument would be that I believe that both of them want to be back together. It would be advantageous to have a signature bond. And there, I get the impression that we're talking about no further violent contact from both sides.
Okay, I'm gonna release her to the hold so she can deal with that. It'll be a $3,000 signature bond through pretrial level 1. 1-day anger awareness, no further violent contact with Ms. Daniels, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Williams. You also, Ms. Daniels.
Your Honor, is that pretrial or jail?
Pretrial.
Next, we're gonna go to position number 2, Mr. Flores.
Good afternoon, Mr. Flores. You've been charged in case 24CR006345C with battery family violence. Is there a history, Ms. Washington?
This is the defendant's first arrest. No history was on file, and the defendant meets the criteria for UJR jail.
Kaki?
Yes, Your Honor. This was the co-defendant in position 5, Giselle Chaveria. Would you like me to go through the facts again?
Briefly, yes, please.
Yes, so of course, this was a dual arrest. The parties are married and share one child, but don't live together. Defendant Flores is accused of putting his hands around Ms. Chaveria's neck and she was unable to breathe. This is after she slapped her. She slapped him 2 times. She had lacerations and marks on her neck. He had bleeding lacerations to his face. The state's recommendation is going to be a signature bond through pretrial services, no further contact with defendant Shabaria, third-party transfer of the minor child, anger awareness, and no drugs, weapons, or alcohol. It's my understanding that the incident location is his home. That's why we're not requesting a stay away.
Yes, who's representing Mr. Flores?
I'm sorry, Your Honor, that's me.
Okay, yes, Mr. Cook.
Yeah, it's my understanding that in fact they have lived apart and they do share child rearing, but have not lived in the same home for several months. So we have no objection to the recommendation as stated by the state.
Okay, it'll be a $2,000 signature bond through pretrial level 1. No further contact with Ms. Chaveria. Third-party transfer of the minor child for visitation, and no drugs, alcohol, or weapons while out on bond.
And Your Honor, I'm sorry to interrupt. My client cannot speak because she's represented and she's in custody, but I did want to speak on her behalf. Obviously, she does not want to have any contact. Her sister, Ms. Chavarria, Carolina Chavarria, is on the line, as well as her mother. They also do not want to have any contact with him, no direct or indirect contact. So they are the family of the victim. So the court, we just ask the court to let the defendant know that nobody in her family wants to have any contact with him.
Okay, so it's not only Ms. Chavarria, but what you said, the mother and the sister, Mr. Jimenez?
That's correct, Your Honor.
Okay.
Yeah, we would have no objection to that as long as they understand the third party transfer process. Obviously, he could not use members of her family then, but they cannot in any way interfere with that process.
So they need to work out third-party transfer of the children without the mother or the sister being involved. Okay? All right, if nothing further, good luck to you, Mr. Flores. Who do we have next?
We have position number 8, Mr. Doherty.
Yes, good afternoon, Mr. Doherty. You've been charged in case 24 CR 006349F with criminal trespass. Is there a history, Ms. Washington?
Yes, Your Honor. The last arrest was in 2020 for terroristic threat and criminal trespass, which the defendant was convicted of. In 2006, the defendant pled nolo to criminal trespass. In 2009, there was a misdemeanor conviction for criminal trespass and simple assault. In 2007, there was a misdemeanor conviction for giving a false name. In 2014, there was a felony conviction for criminal damage to property in the second. 2015 misdemeanor conviction for willful obstruction. 2016 felony conviction for forgery. 2017 misdemeanor conviction for simple battery. There were misdemeanor convictions for criminal trespass also in 2015 and 19. And in 2019, the defendant pled nolo to theft by shoplifting. Also, there were arrests for criminal trespass in 2007, 2008, and 2014, and no disposition was listed on either three of those arrests. There was an FTA in 2018, and the defendant does meet the criteria for level 3. Nothing further.
Ms. Bukaki?
Yes, Your Honor. This incident occurred at the Shell gas station located at 3160 Greenbrier Parkway Southwest in Atlanta. The defendant is accused of damaging the window to the gas station by engraving markings on it with a yellow rock. The state's recommendation is going to be a signature bond through pretrial services. Stay away from the incident location. No further contact with Mike Panjawani and Pradeep Labana, who work at the Shell gas station. No drugs, weapons, or alcohol while out on bond.
Any objection to any of that, Mr. Cook?
No objection, Your Honor.
Okay, it'll be a $2,000 signature bond through pretrial level 3. No further contact with the alleged victim. Stay away from the Shell gas station on Greenbrier Parkway, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Doherty.
Next, we have position 14, Ms. Hill.
Good afternoon, Ms. Hill. You've been charged in case 24 CR 006353D with theft by shoplifting. There a history, Ms. Washington?
Yes, Your Honor. This is the defendant's 11th arrest. The last arrest was in May of this year for giving a false name and theft by receiving stolen property. In 2017, there was a misdemeanor conviction for reckless conduct. 2019 arrest for giving false name. No disposition was listed. A 2022 arrest for battery substantial harm, which appears to be open. And there is also a 2023 arrest for battery. There appears to be a case that is in judicial hold from 2019 for an aggravated assault with a deadly weapon and possession of a firearm during and cruelty to the third. There is an open case, 3 open cases that I'm seeing. One from 2023 for willful obstruction, theft by shoplifting, and escape, and that offense date was May of last year. And also a 2024 open case for theft by shoplifting, giving false name, and escape. Also, an open case in the cab for theft by shoplifting, and that offense date was September of last year. There's also a hold out of Marietta for an FTA, and that warrant date is August 9th of this year. The defendant meets the criteria for level 3. Nothing further.
That's my case, Your Honor. The defendant does appear to have multiple open cases in felony court. The shoplifting associated in those cases are not felonies themselves. She's actually being held on the felony escape charge for those. She does have 2 open shoplifting cases as well, one in Cobb and one in DeKalb County. So although there are multiple arrests, we don't have the predicate required convictions for felony level shoplifting at this point. This is an incident that occurred on the 2nd of September, Your Honor, at about 4:55 p.m. The defendant was seen on surveillance entering the Urban Outfitters at 1061 Ponce de Leon. She was caught on surveillance entering, walking around the location, putting numerous items into her bags without paying, getting on the phone, and then making her way underneath a chain to a restricted area where she then left out the emergency exit. She was seen to get into a gray SUV. Surveillance from the neighboring location was reviewed, and the SUV was identified. When police reviewed all of this information, they also recognized the defendant because she had multiple other open shopliftings, and those are the ones that are open in felony court right now. We're asking for $1,000 surety bond, Your Honor, and to stay away from the location at 1061 Ponce de Leon. She's accused of stealing multiple items of clothing while in the Urban Outfitters. Value in this case is $277.97. Thank you.
Ms. McLean, is this your case?
It is, Your Honor.
Okay, Ms. McConkey, I think we're getting some feedback from you there. Would you mind muting for us, please?
I apologize, Your Honor. I thought I was on mute.
Okay, thank you. Yes, Mr. McLean.
Your Honor, while certainly what the state is proposing is within the range of reasonableness, also would be within that range of the consideration of a signature bond so that she can get on with her holds.
Okay. It'll be a $500 good bond. Stay away from the Urban Outfitters on Ponce. No drugs, alcohol, weapons while out on bond. Good luck to you, ma'am.
Thank you.
That's it from ACDC, Your Honor. Thank you for everything. Bye.
All right, thank you. See you next time.
Okay.
Next, Your Honor, this is going to be position number 9, Mr. Fant.
Yes, good afternoon, Mr. Fant. You've been charged in case 24 CR 006344G with battery family violence. Is there a history, Ms. Washington?
Yes, Your Honor. This is the defendant's 4th arrest. The last arrest was in 2022 for theft by receiving stolen property, which the defendant is currently serving 5 years on probation for that case under the first offender. There is a 2021 misdemeanor conviction for a DUI, and the defendant does meet the criteria for level 1.
Your Honor, that's my case. This is an incident that occurred on the 8th of September. So yesterday, between 9 p.m. and midnight, police were called to a location in Roswell. It's 1065 Anston, Anston Drive. I believe that's the residence of this defendant's mother. Her name is Michelle Fant. On the scene where police were called to a physical dispute, they spoke to the defendant's brother, Stanley, last name Fant as well, who reported that he'd been struck in the face with a closed fist by his brother. Police saw that he had a laceration to his lower lip. Stanley reported that there had been an incident because the defendant, who has a drinking problem, was upset. He'd been broken up with recently, and he had been consuming a lot of alcohol. He wanted to drive. The defendant became angry. He slammed a glass bowl on the table and cut his own finger, and then approached his brother and punched him in the face. This was witnessed by their mother, Mrs. Fant, who spoke to police. She said, again, that her son had been drinking and that she watched him strike her other son in the face. She was seen to have blood on her clothing from the bloody cut that Tanner Fant in front of you had. He is on first offender. He's got, looks like multiple issues going on here. I do not believe he lives at the residence with his mother, but I'm not sure. We'll have to ask the defense. We did speak with the victim in this case, Stanley. So the brother of this young man, he says they don't live together and that this residence is their mother's. He wants no contact and he'd like him to be ordered to stay away from his address. That's 131 Barkley Lane in Atlanta, Barkley. We'd ask for a $2,000 surety, Your Honor. He's on first offender probation. He's got DUIs, burglaries, and thefts in his history. No contact with his brother Stanley and stay away from Stanley's residence. I'm not sure if he lives with his mother at the Anston Drive address or not. If he does not, we'd ask that he stay away from that location. No drugs, alcohol, or weapons, no violent contact with his mom. Thank you.
If Stanley Fant or Michelle Fant is on the line and wishes to address the court, now is your opportunity to do so. Mr. McLean?
Yes, Your Honor, we'd ask the court to consider a signature bond given that there was just a small incident. We could find out who lives where. That would be useful.
Find that out now.
You don't live where? I don't live in her house. He doesn't live at her house, so he's got his own place. Okay.
So we'd ask for a stay away from that location and no further violent contact with his Michelle Fant.
Okay. It'll be a $5,000 signature bond through pretrial level 2. No further contact with Mr. Stanley Fant. No further violent contact with Ms. Michelle Fant. Stay away from the Anston Drive address and the Barkley Lane address. No drugs, alcohol, or weapons while out on bond. Good luck to you, sir.
Thank you, Your Honor.
Next, Your Honor, we're going to go to position number 12, Mr. Hamblin.
Okay. Good afternoon, Mr. Hamblin. You've been charged in case 24 CR 006352E with battery. Is there a history?
Yes, Your Honor. This is the defendant's 18th arrest. The last arrest was in 2022 for criminal trespass. No disposition was listed. 2007 misdemeanor conviction for criminal trespass. 2009 misdemeanor conviction for giving a false name and possession of marijuana less than an ounce. 2010 misdemeanor conviction for possession of marijuana less than an ounce. In 2012, the defendant received first offender treatment for aggravated assault, and that was sealed in 2017. 2012 arrest for battery and cruelty second, and there was no disposition listed, but that was out of DeKalb County. The defendant also pled nolo to possession of marijuana less than an ounce. It appears that the defendant has 2 holds, one from Decatur for an FTA, and that warrant date is March 6th of this year, and also one out of Hateville for an FTA, and that warrant date is July 10th of this year. The defendant does meet the criteria for level 2, nothing further.
Yes, Ms. McConkey.
Yes, Your Honor, this incident occurred on September 7th. The incident location is 985 Smith Street Southwest in Atlanta. The defendant is accused of slapping a Ms. Quanda Lumpkin in the face, causing bruising around her eye and a laceration to her lip during a verbal altercation between the parties. Our office has had an opportunity to speak with Ms. Lumpkin, who confirmed that her and the defendant were dating. They do not live together and they share no children. She stated the incident location is where the defendant lives and that the parties were having an argument that started at her residence, and then they got into the car to drive to the defendant's residence. And while they were in the car, the defendant was yelling at her and then backhanded her in the face. She states this is not the first time the defendant has been violent towards her, but this is the first time he has been arrested for violence against her. She is planning on filing a TPO, and she wants no contact with the defendant and wants him to stay away from her residence, which is 7570 Crawford Court in Fairborn, Georgia. The state's recommendation is going to be based on the defendant's history, which includes numerous arrests and convictions for violence. Our conversation with this victim, the fact that they have had violence in the past does raise a concern for some intimidation, and the fact that he has numerous FTAs shows that he does not like to respond to the legal process. So we are requesting a $2,500 surety bond, no further contact with this victim, stay away from the victim's residence, anger awareness, no drugs, weapons, or alcohol. Also stay away from wherever the victim works as well.
Ms. Lumpkin, if you would like to address the court, now is your opportunity to do so. Of course, you don't have to, but if you would like to address the court, I need for you to unmute yourself, activate your camera, and I'll have to swear you in. Okay, it does not appear so. Mr. McLean? You're on mute if you're
This is
speaking.
by case, Your Honor.
Oh, okay, yes, Mr. Cook.
Yes. Your Honor, my client is 39 years old. He's worked in this area, lived in this area for 29 years. He is a barber. We have heard the recommendations. We've heard the background. We would just simply leave it to the court's discretion at this point.
Okay, it'll be $1,000 good bond. No further contact with Ms. Lumpkin. Stay away from the Crawford court address. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Hamlin.
Excuse me, Your Honor.
Yes, Mr. Hamlin, you have a right to remain silent. Anything you say can be used against you. Mr. Cook, you want to address your client?
Mr. Hamlin, I would ask you not to speak. Just in my experience, I think you got a reasonably favorable bond, and I would again ask you not to speak, and you can deal with the issues of the allegations once you leave Rice Street.
I just wanted to know, I don't understand the term of the bond. I just wanted to get it reiterated. I didn't really hear what he said.
Go ahead, Mr. Cook.
It's Ms. Hamlin, it's $1,000 bond, money surety bond. That's a money bond. You can either you could pay the entire amount yourself. You could probably still go through a bondsman at that level and only pay a percentage of it to the bondsman as a fee for them to put the remainder up for to get you out of court. You cannot have any more contact with the person who made the allegations. I believe that's Quanda Lumpkin until and unless the bond is modified or this case is ultimately disposed of in a way that would allow you to have contact. You are to stay away from the incident location, and you're not to have any illegal drugs, alcohol, weapons, or firearms. Again, this could be subject to a modification of bond down the road, and then a lot of things change once the case is disposed of. And by disposed of, I mean it comes to there are a whole array of ways a case could be disposed of, but usually it's in a determination of guilt or innocent.
Okay, thank you.
Sure.
All right, and then Ms. Lumpkin, he's not to have any further contact with you while he's out on bond.
Would that
Okay, I wasn't able to unblock my turn off my mute and turn my video on. That's why I didn't respond immediately. But I do fear for my life, so I want to make sure that the court does know that I did file a TPO today and it was granted. So I just want to make that known.
Okay, thank you for being here, Ms. Lumpkin.
Thanks.
Who do we have next?
Next is going to be position number 16, Mr. Jolly.
Good afternoon, Mr. Jolly. You've been charged in case 24 CR 006356D with simple battery against a police officer, obstruction of law enforcement officer, and theft by shoplifting. Is there a history, Ms. Washington?
Yes, Your Honor, this is the defendant's second arrest. The last arrest was in 2021 for battery. No disposition was listed. The defendant does meet the criteria for UJR jail. Nothing further.
Pataki?
Yes, Your Honor, this incident occurred at the Publix located at 3695 Cascade Road in Atlanta. The defendant was seen coming from the Publix deli area with food that he did not pay for. When the officer told him he had to go pay for the item, the defendant refused. And when the officer attempted to grab the bag containing the item from him, the defendant pushed the officer and told him that he didn't need to show a receipt. And then the parties began to tussle as the defendant took a fighting stance against the officer. The defendant was eventually tased, but he managed to flee to a nearby store that he worked at, and then his manager locked the door behind him. The state's recommendation is going to be a signature bond through pretrial services, given the defendant's limited history. No further violent contact with the officer, M. Hunt. Stay away from that incident location. No drugs, weapons, or alcohol while out on bond.
Any objection to any of that, Ms. Holly?
No objection, Judge. We're good with all of that.
Okay, so for the simple battery, a $2,000 signature bond through pretrial level 1. For the obstruction, a $1,000 signature bond through pretrial level 1. Theft, $1,000 signature bond through pretrial level 1. Makes for a total of a $4,000 signature bond through pretrial level 1. No further violent contact with the officer. Stay away from the Publix on Cascade, and no drugs, alcohol, weapons while out on bond. Your client has his hand up, Ms. Holly. I'm not sure.
Mr. Jolly, do you have a question?
You remember what I told you about the Publix? It's a plaza. My job, like right down the
So
block.
you can't enter the Publix, Judge,
Oh.
if we can just make sure. So he works like literally right there. He has a job at a cafe. So I just want to make sure that it's in the bond order that he cannot enter the Publix, but that he will be in that area because he works there.
Okay, so I'm not gonna keep you from working, Mr. Jolly. Just don't go back to that Publix. Go into that Publix, okay?
Yes, sir.
All right, good luck, sir.
Next, y'all, is going to be position number 18, Mr. Mangum.
Yes, good afternoon, Mr. Mangum. You've been charged in case 24 CR 006357G with theft by shoplifting. Is there a history, Ms. Washington?
Yes, Your Honor, this is a defendant's 26th arrest. The last arrest was in June of this year for a probation violation, a 2010 felony conviction for robbery and transaction fraud, 2018 felony conviction for 6 counts of transaction fraud, 2019 felony conviction for ID theft, forgery in the third, forgery first, forgery second, and forgery fourth, and also 4 counts of card theft. In 2022, there was a misdemeanor conviction for forgery in the 4th degree and theft by deception. 2019 arrest for bad checks, no disposition was listed. 2020 felony conviction for criminal damage to property. Second, 2021 arrest for forgery in the 4th degree, which appeared to be dead docketed. 2023 misdemeanor conviction for forgery in the 4th degree, 22 counts. In February of this year, there was an arrest for theft by shoplifting, which appears to be open in Griffin, Georgia. The defendant also appears to currently be on probation in Cobb County, and the defendant meets the criteria for level 3. Nothing further.
Yes, Your Honor. The defendant is accused of shoplifting a Crown Royal liquor bottle from the Gold Star package located at 5056 Old National Highway in Atlanta. The state's recommendation is based on the defendant's criminal history, which shows that he has a propensity for theft and fraud. So there is a very high chance that he will reoffend. We are requesting a $1,000 surety bond. Stay away from that incident location. No drugs, weapons, or alcohol while out on bond.
Your Honor, my client has a job. He works at Popeyes. He has 2 children. They're 3 and 7. The mother of those children passed away in childbirth 3 years ago. He has been employed at Popeyes for the last 5 years. He lives with his mother and his 2 children. She also works and helps care for the children. He does not make enough to pay a surety bond. And Judge, I do believe that he will return to court. We would just ask for this to be a signature bond so that he can get back to his kids.
It'll be a $5,000 signature bond through pretrial level 3. Stay away from the Gold Star Package Store on Old National, and no drugs, alcohol, or weapons while out on bond. Good luck to you, sir.
Thank you. Next, Your Honor, is going to be position number 20, Mr. Price.
Good afternoon, Mr. Price. You've been charged in case 24 CR 006360A with 2 counts of simple battery family violence. Is there a history,
Your
Washington?
Honor, this is the defendant's first adult arrest. The defendant meets the criteria for level 1. Nothing further.
Your Honor, this is an incident that occurred yesterday, September the 8th. Between 11 a.m. and noon, police were called to 2412 Harbor Landing in Roswell. The victim in this case, her name is Gatia Calhoun, and that's spelled G-A''Tia, Calhoun. A third party called the police, and 2 witnesses on scene gave statements. They reported seeing a male outside of the location with his arms around the victim's neck on the ground, strangling her. Once she was released, the victim was seen getting up and breaking the window of this male's car, and that vehicle left the location. Officers responded, used the description of the vehicle, and actually saw it and stopped the defendant driving it. He did have a broken windshield. He was seen to have visible scratches on his body and blood on his hands and forearms. Police made contact with the victim, Mrs. Calhoun, who also had scratches on her arms but wouldn't really be cooperative. She did say that there'd been an altercation and she'd been pushed. We spoke to the victim today. She says they're in a relationship and they live together and they share 2 children, and she's changed her position again. She says that she was never grabbed by the neck and that she actually, instead of being pushed, she fell over her own belongings. And of course, she said she didn't call the police because that's the biggest and most important reason for why we're supposed to believe these things didn't happen. Based on what you've heard in front of you, the fact that 3 different people witnessed this and called the police, we're asking for a $2,000 SOB through pretrial level 1. This gentleman does not have a large criminal history, but we are asking for no contact and to stay away from the location. Again, that's 2412 Harbor Landing in Roswell. No drugs, alcohol, or weapons. And we'd ask for some anger management as well. Thank you.
Hey, Ms. Calhoun.
And if you can sound, I'm sorry, if you could sound for Ms. Calhoun.
Calhoun, I see you on the line. If you would like to address the court, now is your opportunity to do so. I'll need you to come on camera for me.
Hi, yes, I'm trying to connect from another phone because they won't allow me to get on my camera on this phone.
I can't find that Makisha.
Hello?
Yes, ma'am. Can you raise your right hand for me?
Yes, hold on 1 second. Let me get off the other phone.
Okay. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Yes, ma'am. What would you like to tell the court?
Okay, so I wanted to start by saying, for one, I was never pushed or nothing. They seen, as it was shown, the stuff had came from storage. We had just got our stuff from storage the day before. The reason he had came out was because, yes, we were into it, but he was still going to come move the stuff out of the car so that I could see to get around to get my baby some milk. That was the original reason why I was even out and why we ended up getting into it, because we started talking about the car miles, and I was telling him, like, I'm frustrated about the milk at this point. I'm trying to get the baby milk. I'm frustrated. He's trying to figure out, where did the miles go? How did we waste it? Whatever. I'm just telling him, regardless, we're going to have to get more gas. So after that situation, he came out because, like I said, I was already frustrated. So he hung up the phone. We didn't get into an argument. He came out because he was moving the stuff out the car, because I did tell him prior to going that I could barely see. It's already a lot going on. There wasn't taking my food stamp card. I didn't have it on hand. And they wouldn't let me type it in or give it to them to put it in. So I'm like, I had went to different stores at this time, and I'm like, I'm frustrated. So I already went into the situation, feeling away, but he was feeling like he was trying to explain to me that he felt like Even though I was frustrated with other things, I shouldn't let that affect how I'm talking to him or feeling with him, whatever. Understood, but I still need to give my baby some milk, so I still had the frustration. So we end up getting into it, and I can't say I remember verbatim. I'm not gonna say verbatim how the conversation was going, but at this point, I am like very upset. Like I'm upset. We're yelling. We're loud. It is, commotion going on or whatever. And he did grab me. Now, when I told them, they were saying that people were calling and saying that he was choking me on the floor, choking me out, doing that. That never happened. He was grabbing me like, stop. You need to chill out. You need to calm down. These people gonna think I'm doing something to you. You need to. This don't need to be going on. That was how that situation went. Now, like I did say, the stuff was coming from the storage. The police seen it. We had a whole bunch of stuff outside. I did fall. That's how I got scraped. But I could show my neck. I showed the police. They put the flashlight, everything. I never got choked out. That was never the situation. My brother also lives with us. He's older than us. That's my main protector anyway. So if I felt like I was threatened or harmed, I would go immediately would have went to my brother if I felt like it was that type of situation. Like I said, the only reason we were even outside was because we don't like to argue in front of our kids. And he came out because he's like, I'm going to help you regardless what's going on. You said you can't see whatever. Still trying to kind of diffuse the situation, but I was already frustrated, so it didn't go as planned. But there is no issue. Like, I've known him for 6 years plus prior to having kids. We've been best friends, childhood friends or whatever. My children, they love their dad. I would never want it to be no contact situation. Like, this is his home. There isn't I don't feel threatened again. I don't feel like it's anything he can't be around or I'm afraid. Like I said, I also have someone in the home with me, my brother, so who's going to protect me regardless of who he is to anyone else. So I believe that shouldn't,
Did
be the
I hear
case.
that you broke the car window out, Miss Calhoun?
Yes. Yes.
So why would you, if nothing was going on, why did you break the car window out?
No, I did throw something. I threw something.
And where were your children at this time?
They were upstairs sleeping in the home.
They were upstairs sleeping
in our home. Yes.
Okay. And
When
where
we
were you?
walked in, the baby had just woke up. She was looking up. She wasn't whining or anything. The police came in. He was with me. My child was still sleeping. My brother was in the other room sleeping as well. So it wasn't like they were left out in the house while we were. That wasn't the situation.
Okay. Has this happened before?
Never. No prior history, nothing.
All right. Thank you for being
Like
here
I
this
said, we're
afternoon.
just young, and we do, get frustrated. And I do have 2 children under 2. I am going through postpartum, so I do sometimes I do get angry and I do get upset. But he was trying to calm me down and get me. That's what the touching me even came about. It was never I don't feel threatened by him or feel like he wanted to harm me or would harm me ever.
Thank you for being here, ma'am. Mr. McLean?
Not much to add, Your Honor. Thank you. Signature bond would be great.
All right. For each charge, it'll be a $2,000 signature bond through pretrial level 1. 5 days of anger awareness, no further violent contact with Ms. Calhoun, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Price. You also, Ms. Calhoun.
Appreciate it.
Thank you.
Please.
Who we have next?
Position number 23, Mr. Stanley. Brian Stanley. Hey, y'all sit down. Y'all still in the courtroom, man. Come on now. Find a seat and find a seat. You too, Mango.
All right. Good afternoon, Mr. Stanley. You've been charged in case 24 CR 006340J, with criminal trespass and theft by taking. Is there a history, Ms. Washington?
Yes, Your Honor. This is a defendant's 14th arrest. The last arrest was in 2023 for a hit and run, and no disposition was listed. There was a 2008 misdemeanor conviction for theft by shoplifting, a misdemeanor conviction for furnishing alcohol below the legal age in 2007 and 2009. In 2015, there was a felony conviction for fleeing, as well as a misdemeanor conviction for DUI, driving while license suspended or revoked, and willful obstruction. The defendant was arrested for fugitive in 2011, 2012, and 2015. The defendant meets the criteria for level 1. Nothing further.
Your Honor, this is an incident that occurred on the 6th of September between 10 a.m. and 1 p.m. at 95 8th Street. I apologize, Northwest. That's the Momo Cafe, MOMO. Police were called to the location when the manager, Mr. Daniel Song, reported that someone had barricaded themselves inside the office of the restaurant located on the 6th floor. Somebody had left the door unlocked, and that allowed the defendant in front of you to make his way inside. He'd pushed shelves in front of the door of the office to barricade himself inside. Police helped make entry into that office. They observed that it had been ransacked. The shelves had been pushed over to prevent someone from coming in, and the defendant was located under some clothing. He had a wallet bulging in the pocket of his pants that was revealed to be the wallet of Mr. Daniel Song, who'd called the police. He's the manager at the location. The defendant was seen to be drenched in sweat. He claimed he was an employee of the location, which was not the case. He appeared to be under the influence. He asked for some support and said he was having a mental health crisis. I believe he was evaluated before being taken into custody. We just heard he's got a substantial criminal history that involves DUIs and substance abuse, Your Honor. We're asking for $1,000 surety to be ordered to stay away from the location. Again, that's 95 8th Street Northwest. No drugs, alcohol, or weapons while on bond. Thank you.
Holly?
Judge, this is a mental health case. He does have diagnoses, bipolar and schizophrenia. I would ask for a signature bond. He intends, I spoke with him. I don't have any concerns about competency. I spoke with him. He plans to go and get an evaluation. His cousin, Lauren, who he lives with, is also aware. So we just asked for a signature bond so he can go and get that done.
Okay, give you $1,000 signature bond through pretrial on each charge, makes for a total of a $2,000 signature bond through pretrial level 1. Stay away from Momo Cafe on 8th Street. No further contact with Mr. Song, and no drugs, alcohol, or weapons while out on bond.
Thank you, Judge.
Good luck to you, Mr. Stanley.
Thank you.
You're welcome.
Next on, we have position number 24, Mr. Stevens, Marquez Stevens.
Good afternoon, Mr. Stevens. You've been charged in case 24 CR 0063398 with 2 counts of simple battery, family violence, and criminal trespass and damage to property. Is there a history, Ms. Washington?
Yes, Your Honor. This is the defendant's 3rd arrest. The last arrest was January 16th, 2024 for simple battery, which appears to be open, and the defendant is currently on pretrial for that case. We will be surrendering the bond. The case number is 24 CR 0000388 H as in home. The defendant does meet the criteria for level 2. Nothing further.
Okay.
Your Honor, this is an incident from September the 7th. Police were called to 3280 Spanish Trail, apartment 6 in East Point. On the scene, the victim in this case, her name is Shakira Jones, and that's spelled Chakira. She reported that she made the defendant angry when she left his phone outside and it fell off of a truck it was sitting on. He got upset and thought she was trying to get back at him and break his phone because he broke her phone last week. And he punched her in the face, and she reported that she was choked. She said she ran inside, and locked the door and took their infant to try to get away from the defendant. He then kicked the door open and caused damage to that wood frame. Apartment maintenance reported to police that the damage was going to be about $300. He does have an open simple battery family violence, Your Honor, from January. He is out on bond right now, and it is with the same victim. It includes obviously no contact, I think, but also a curfew. And let me pull it up. Based on the fact that he's out on bond for a call against the same young woman, we'd be asking for a $2,000 surety No contact with Mrs. Jones. Stay away from the location at 3280 Spanish Trail, apartment 6, and no drugs, alcohol, or weapons. And the bond order says no further contact with Ms. Jones. 1 day anger awareness, must finish school or get his GED, curfew 11 p.m. to 6:30 a.m. And that's Judge Mincy, January the 17th. And you just heard pretrial say they were going to come off on that bond. Thank you.
Judge, I do have a question. Is it possible for us to address the bond on the other case as well while we're all here?
I feel more comfortable addressing the bond on the other issue at the SAP calendar as opposed to this calendar, because what was it, Miss Allen? It was through pretrial. What is the amount of the bond? Does she put amounts on hers like I do?
I think she has to.
You're on mute, Miss Allen, if you're.
It's a $1,500 SOB through pretrial services, level 1.
All right, so
And
it's going to be.
she waived the requirement for a cosigner.
Okay, so it's going to be a $1,500 good bond. So I think that's adequate.
Okay.
All right, go ahead.
Just as a note, my client states that the apartment door was already broken, that he did not break it, but also they share a 10-month-old baby, and he's currently on Social Security for a mental health disability as well as ADHD. I would just ask the court set a reasonable bond in this case, and I'll speak with his mom about what that looks like since the other bond is being revoked.
Okay, and I'll be on the SAP calendar on September 24th. If you'll have whomever's representing him at that time speak with me about the MH, I will go back and revisit at that time. But as far as today goes, it'll be with a criminal trespass, a $500 good bond, and for each of the simple batteries, a $1,000 good bond, makes for a total of a $2,500 good bond. No further contact with Ms. Jones. Stay away from the Spanish Trail address. No drugs, alcohol, weapons while out on bond. And if he does not make bond, I will address him again on the 24th.
Okay, thank you. I'll give his mom a call.
All right.
Will he need well, I guess it's a bonding company, so he won't need a cosigner.
We did try to make contact with the victim, Your Honor. We just weren't successful yet today.
Okay. Thank you. All right. Good luck to you, Mr. Stevens.
FYI, Your Honor.
Yes.
Miss Quinetta Jones, I don't have her position number. She refused to come to court or to be interviewed. She said she was not feeling well.
Judge, this is the second time she's been reset. I believe she was reset from Saturday. And just based on the allegations in the warrant, I would like for her to be reset to competency.
Okay.
If we want to do a little breakout session, I can give the court a little more information.
Have you spoken with her, Miss Holly?
No, but also yes. It's
Okay.
kind of complicated.
All right, I'm only asking you that because, if you can get a waiver, we could deal with this, get her a bond at least, and then I've got to set her a bond, right?
Yeah.
So, and
she's refused both times to speak to our office when we've tried to talk with her.
Attorney
Okay.
Holly, are you going to be here tomorrow?
No.
Okay.
Um,
I would try to get a phone to her and see if I can get her interviewed.
Okay.
Is it possible to take a cell phone to her now so she can be appraised of her charges and we can deal with the Riverside issue?
Yeah, all that needs to happen is that I just need to ask her if I can waive her presence.
Okay. I will call you at 678-744-4868. Give me 10 minutes.
Okay, thank you.
Thank you.
You're welcome.
Okay, who do we have next?
Your Honor, position number 22, Jason Smith, That's gonna be an MH reset. He's in site op. Mr.
Okay,
McClain did speak to him. He did speak to him. He might wanna give you some more insight.
Your Honor, that should be an MHET. I think we need some time on that.
so you want me to reset him for tomorrow?
Not tomorrow. I think maybe we should, give it a couple of days. I'll have a social worker talk to him tomorrow morning.
Yeah. So
It's not a big case, though. The state might disagree. Maybe we should go forward tomorrow, but I think about 2 days would be good.
Well, I can't just let him sit there without a bond, so.
Right.
So why don't we try to get him for tomorrow, and if something
Tomorrow's fine.
happens, I'll discuss it with you then.
Very
Okay?
good. Thank you.
All right, so we'll reset him for 9:10. I'm the judge for tomorrow too, so.
Thank you.
Okay. We have anyone else?
That should be it. Unless I'm missing someone.
Did you all see the other add-on?
Who was the add-on, Ms. Bridgewater?
Purvis Kane?
He bonded out. He paid his
Okay, he
bond.
bonded out, okay.
15,487. Anyone else?
And also, how about number 6?
5 weeks or 5 months. Who's number 6? She's pregnant.
Deja Coleman?
Yeah, we've done,
Did I
we did
miss
that.
her? Okay, maybe I missed marking it, hold on. I'm so sorry, yeah, I see we had a $3,000 SOB through pre-trial. Okay,
all right, so, while we wait for Officer Milton, why don't we, go through the calendar? If that's
okay,
okay?
that's perfectly fine with me.
Okay,
Okay, position number 1 on the regular calendar is reset further notice with a total $2,000 SOB through pretrial. Position 2 is reset further notice with a $3,000 SOB through pretrial. Position 3, I have paperwork all over my desk. I'll come back to that one, okay? Position 4 is reset further notice with a $2,000 SOB through pretrial. 5 is reset further notice with a $3,000 SOB through pretrial. Position 6, reset further notice with a total $3,000 SOB through pretrial. 7, reset further notice with a total $1,000 SOB through the jail. 8 is going to be reset further notice with a $2,000 SOB through pretrial. 9, reset further notice with a $5,000 SOB through pretrial. 10, reset further notice with a total $4,000 SOB through pretrial. 11, reset further notice with a total $5,000 SOB through pretrial. 12 is going to the SAP calendar with a $1,000 good bond. 13, reset further notice with a total $5,000 SOB through pretrial. 14 is going to the SAP calendar with a $500 good bond. 15 is going to the SAP calendar with a total $2,000 good bond. 16, reset further notice with a total $4,000 SOB through pretrial. 17, we're going to see about her. 18, reset further notice with a $5,000 SOB through pretrial. 19 is reset further notice with a total $5,000 SOB through pretrial. 20, reset further notice with a total $4,000 SOB through pretrial. 21 is reset further notice with a total $4,000 SOB through pretrial. Position number 22 is being reset till tomorrow. 23 is reset further notice with a total $2,000 SOB through pretrial. 24 is going to the SAP calendar with a total $2,500 good bond. 25 is reset further notice with a $2,000 SOB through the jail. 26 is reset further notice with a $2,000 SOB through pretrial. 27 is going to the SAP calendar with a total $1,000 good bond. 28 is reset further notice with a $3,000 SOB through pretrial. Also on the add-on for Miss Bell, Ashley Bell, she has been reset further notice with a $2,000 SOB through pretrial. And the young lady that we added a case to that we didn't have,
Mrs. Ford.
huh?
Mrs. Ford?
Ford?
Yeah,
Maybe, I have so much on this.
I think it is. I think it was the theft question. LaShonda
Very
Ford.
well be in the, XIU, we added a charge on that one, didn't we?
No, that's not accused. That's just a bond.
Right, but I was gonna give you the bond amount, but I guess I can't do that because I can't find all this in it with all this paper on my
I'll
desk.
give you a minute.
Why did you
And
say
Judge,
that?
I
You
just
will give me
spoke
an
to
excuse
Miss.
not to have to go through all of this, but thank you for your help. Okay, so with that being said, it was somebody, okay, Ford, hold on. Let me give you those, oh, Miss Black. Let me tell you what the amounts were for Miss Black. She was position number 3. Oh, boy.
I think on Black, it was 1,000 on number 1, 2,000 on number 2.
Right, that's a $3,000 total SOB through pretrial. And Miss Allen, you mentioned somebody, oh, Miss Allen. We had a case last week that I need you to send me the transfer order to juvenile court.
Okay.
You got that order,
Yeah.
okay?
Yes, ma'am.
Ms. Bridgewater, just for clarification, on position 5, I had a $2,000 signature bond through pretrial.
Okay. Perhaps you did, it gets a little muzzled on my end, but I'll change it to $2,000.
Is that what everybody else had? Position number 5?
Is that Miss Chavaria? Yes, I had a $2,000 SOB, and then I also had a $2,000 SOB for Mr. Flores, position 2.
Okay, hold on. For position 5, we said a $2,000, right?
Yes.
And who was the other case you said you had something different for?
Position 2, Flores, I had $2,000.
That's what I have.
Okay, not a problem. I will make sure these are corrected.
Thank you.
Mm-hmm.
And you have an announcement, Ms. Holly?
Yes, Judge. Can we get just a quick breakout session on this? I know, I mean, or we can, I think the calendar's over if you want to just take the recording off the live.
Okay, can we just go off YouTube?
Hold on one second, okay?